That's right, ladies and gentlemen. If you got a problem and you're the underdog, we got some awesome attorneys here. Super Attorney Rick Dodd to my left. Also, you heard Attorney Extraordinaire Ben Ross Watson. You got a great team going on here. So, Copeland & Dodd Crabes Law Firm, they sponsor this segment. They do a fantastic job for supporting us, and we can't thank them enough. Rick, welcome to the show.
Good to be here. I still take issue with your underdog. Most of my clients are really heroes. They get in situations that normal people find themselves in abnormal situations. And the best clients, of course, are heroes in that they persevere and push through it and do good things for themselves and their family, even under those abnormal circumstances.
Well, then maybe I'll have to look for some better music. I'll find some.
Well, what I do is the respectforyou.com is our website, and I think
mental note,
our
Joel,
clients need
mental
respect.
Note, coming in and going out of this segment, we're going to do respect, okay? That's what we'll do. All right, Rick, I talked to you about rhetoric. We got lots of rhetoric going on, but let's touch on the license to carry aspect of it. If somebody...
Well, let's first talk about some rhetoric. What is rhetoric? And of course, these days, most people look at rhetoric as being a negative thing. You say, oh, well, that's just a bunch of rhetoric. The truth is, rhetoric is just a style or a science, if you may, of persuasion, oral persuasion. And it's been going on forever. Like, for instance, back in the day of Plato, he studied rhetoric and wrote about rhetoric. And he says that rhetoric was the persuasion of ignorant masses within the courts and assemblies.
Oh, man, that's perfect.
Yeah.
That's definitely what's happening.
He says that, in his opinion, it's merely a form of flattery and functions similar to cookery, which masks the undesirable and unhealthy foods by making it taste good.
That's awesome.
So rhetoric's been around for a long time, and when we talk about rhetoric these days, it's usually in a political realm, but also it can be in a scientific realm. These days, more so than other days, at least in my career, scientists have to use rhetoric, if you may, to persuade their audience that their science is good and sufficient, and by demonstrating that they used the correct number of people to make their study, that their likelihood of it being correct is up in the 98th percentile. In other words, there's court cases that require these things today, that if I'm going to use science in the courtroom, I have to prove the likelihood of it being good science as opposed to junk science, which makes perfect sense.
But you're putting rhetoric in a good spotlight, saying you're just trying to persuade somebody for good reasons. But
yeah,
we're also going to get into why rhetoric can be.
Well, we normally would talk about that as being poor rhetoric or emptying rhetoric. Talk about empty promises. A lot of negativism goes into the word rhetoric, but it is a art, if you may, a science and an art on how to persuade people. That's the bottom line. And when you talk about manipulation, that's sort of a negative term, as opposed to shaping our society. Some of the old guys that, like Socrates and Aristotle, one of his students, they used rhetoric to shape their societies, the Romans and the Greek, which was a good thing. They used rhetoric to bring people together in such a fashion that they could be a government. And this was some of the first governments, and of course we know the Roman Empire was successful for a long time because of their rhetoric.
It's very, you're saying all this stuff, and I just never looked at it that way. And then when you read that from Socrates, it just molded it all together for me. I get it, but how do you combat it if you don't want the rhetoric?
Well, Cicero says that in order for it to be good rhetoric, the person delivering has to be a good person.
Yeah, how do you...
Person who is enlightened on various civil topics, someone who, in other words, knows a lot about people, biology, the environment, protection of people's rights, and so forth. So when you hear someone talking and your mind immediately starts clicking saying, oh, that's rhetoric, that ain't good, then you can kind of bet that that person is not under the, and I'll use my little quote fingers here, good person category.
It'll be on video, you'll be right. Okay.
So there are ways to train for rhetoric.
what, to train to know when you're getting rhetoric, or train on how to give rhetoric?
On how to give rhetoric.
Okay.
Yeah, they're actually, well, like the Harvard debate team. They study rhetoric all the time on how to deliver stuff in a fashion that is believable. And there are, certain ways to do that. First, you have to initiate what you want to talk about. You have to organize what you want to talk about in some sort of a fashion so that when you do talk about it, the other person gets it. Then you have to study certain words like, manipulate and those kinds of words we just talked about, whether you want to place them in certain areas. And then when you deliver it, you have to be animated. There's actually a study of animal rhetoric where people look at animals and how they communicate with each other. And as human beings, as we are animals, the way we deliver our rhetoric is important with our hand gestures, the way we inflect our voices. And then after we do that, we have to memorize a lot of the stuff we're going to say, because if we read it, it's not going to be as believable as we animate it and deliver it off the cuff.
Okay, let me ask you a question. You're talking about animals. The first thing I thought it was a gorilla. A gorilla comes up, starts beating his chest. Is that rhetoric, or is that just a normal thing for a gorilla to do to warn an animal that, hey, I'm about to pounce on you? How do you differentiate rhetoric? And then when you put that to the human sense, how does one person do a normal response that you would think is normal to a situation? How do you define it from being normal as compared to it being rhetoric?
Well, rhetoric is normal. I mean, we communicate all the time using symbols, and voice is a symbol. In other words, when I say something, your brain computes it into information, which is then soaked into your brain and believable or not believable, however you want to, but it's still rhetoric. When the gorilla comes up and beats his chest, another gorilla, maybe bigger and more powerful, looks at that and goes, oh, well, that ain't nothing. He does that every day to me. Whereas another gorilla might cower into the corner because he knows the next step is going to get him beat up. So
then what you're saying is the word rhetoric is kind of like the word brandishing, because a long time ago, I thought the word brandishing was meant where the person draws the weapon out and starts waving it around. And it also means, I found out, that if I'm in Penal Code 904, threat is justifiable force, and I open up my jacket and show my weapon, that is brandishing. But it's not in a criminal sense, it was in a protective sense. So the word rhetoric, you're saying, is used for both. Rhetoric is a person's ability to communicate in whatever may be perceived as normal to somebody else.
right.
Wow.
Yeah.
I got it right from Rick. That's really good.
So there is, like Aristotle, he talked about the different types of rhetoric. Forensic, which is one that I'm involved in a lot, it has to do with the judicial process. So forensic rhetoric might be me delivering an open statement or a closing argument in front of a jury, or my witness or my client might be delivering their story to the jury. So forensics, as we know, has to do with everything in the courtroom. A lot of us talk about forensics in the way of pathology, where a pathologist comes in and talks about the bullet wound, exit and entry and all that good stuff, DNA. So that's forensic. Then also you have your deliberative. And deliberative, according to Aristotle, is what we see in politics. And of course, we're getting a big dose of deliberative rhetoric these days, all over the place.
All over the place, yes.
All over the place. So anyway, then there's the ceremonial rhetoric, and that is, what we usually see in like eulogies or wedding toast. In other words, we compliment someone or wish them goodness for the rest of their life. And of course, we do all these kinds of different rhetorics all the time in our lives.
So why do you think that they're using the key word rhetoric as, it's almost, the word rhetoric is almost rhetoric and manipulation to make it sound like it's so bad what people are doing, when in reality it may be just a person challenging another person to a challenge of them saying you're one way and they're denying it and saying it that they're not in another way.
Yeah, that's
I'm
right.
confusing myself, I think.
Well, we've kind of, we as human beings always take our shortcuts, and we've heard so much about empty rhetoric and bad rhetoric. Well, we just started leaving those off. Now we just talk about rhetoric. Oh, that's just rhetoric. And see, when I use it, I kind of growl. Oh, that's just rhetoric.
That's rhetoric.
Yeah. So we've communicated the fact that we don't like it just by the way we've said it, or our actions when we like pump our fist up in the air. It's just rhetoric. So that is just rhetoric.
I've got all these articles here, and I know you've got articles too. And the reason I cut them out was just, it was right there in the headlines.
Oh, it's just rhetoric. And, you know, anytime you pick up the Temple Daily Telegram, you turn to page, I think it's page 4 these days, you're going to see rhetoric. And in my opinion, it's going to be rhetoric from the right side, because Temple Daily Telegram is in business.
Well, this was on page 2, by the way.
Okay, well, I'm talking about the editorial page. Okay. And when you are in the business of marketing, you use a lot of rhetoric, right? So a newspaper has to market its product. So guess what? It's going to speak to the people that are going to buy newspapers. So the folks that are going to be reading the Temple Daily Telegram would fit into a special group of people who would like to read what we would normally see as right-sided rhetoric. So that's why when you look at the editorial page, you always see the cartoon as being right-sided. Now, you know, there are a few exceptions, very few, and gosh, as I've watched and read the Temple Daily Telegram for about 40 years, I've seen the exceptions become fewer and fewer. In fact, I don't recall seeing an exception now for about 2 years, but I'm sure somebody could find one.
Write an editorial on it and send it in. Maybe they'll publish it.
Oh, I don't do it. There's plenty of people that do that already.
The top headline here reads, "Anger towards news media spreads into local communities." And then the headline below it goes, "Trump escalates anti-media rhetoric after wave of violence." So it's pandering to both sides with the rhetoric. And I'll tell you what, before we go any further, since this is a gun show, can we encapsulate this rhetoric and how it can be used negatively or positively or whatever in a self-defense mode or an escalation of self-defense, and how it can potentially bite you in the rear end?
Oh, sure we can. Absolutely. In fact, it's written into our laws. For instance, when we look at Penal Code Section 9.31, the self-defense, which we've talked about extensively on this show, and then we look at the use of deadly force and the ability to counter that with your own self-defense, you have to know that you cannot provoke the person against whom the force was used. And so here we'll just use the word provoke as in place of rhetoric. In other words, you can't provoke someone with your rhetoric into attacking you and then say, oh, this was self-defense. And, you know, the use of, and also it has to do with the fact that if you are being provoked, in other words, if someone else is provoking you, and you use the word brandishing a gun and things like that. Remember, we have to look at it from the view of the person who's shooting. Now, we're talking about two different people here. First off, we were talking about the defendant. Now we're talking about the victim. If the victim uses verbal provocation only, you can't act in self-defense. In other words, you can't go after them with your gun and shoot them. So those are the rhetorical things with regard to self-defense. And there are a bunch of cases that talk about what is and what is not provocation. So I guess we could talk a little bit about that. When we are talking about what is and what is not provocation, you have to remember that some of the case law says that someone may have a perfect right to self-defense, though he may not be entirely free from blame in a transaction, if the blame or wrong was not intended to produce the occasion. Now, that's sort of convoluted, but it requires an intent on behalf of the shooter, the defendant in this case. In other words, did I provoke this? Well, if I intended to provoke it, that goes a long way, right?
I would think so, yeah.
Yeah, it goes a long way if I intended to provoke it. But just the intent alone is not enough, our case law says. He must have said or done something for the purpose of inducing an attack upon him, which was calculated to bring about that attack. So there's some case law that talks about...
Can you clarify that in layman's terms?
Well, yeah. If, say for instance, I intended to piss somebody off and get them to attack me so I could shoot them. But I didn't actually do anything. I just stuck a pistol in my belt. And, I had every intention of provoking, but I didn't quite get that far because he was already provoked. Then I could use self-defense as a defense.
That'd be very hard to prove, wouldn't it?
Well, again, the totality of the circumstances
Okay.
really is what we're looking at when we go into the courtroom. And the state has the burden. It's a pretty powerful burden, beyond a reasonable doubt. So if the jury decides that the totality of the circumstances will not allow them to convict this person beyond a reasonable doubt, then he goes free.
I'm bouncing back and forth here. Can you clarify the preponderance of the evidence and what you just said, which was
Well, preponderance is basically a more than 50%. In other words, the probability, preponderance, probably. So when you and I talk about probably, we're talking about most likely. In other words, more than 50%.
and that would be used in something that's not like a deadly situation, right?
Well, it certainly can be a deadly situation in civil cases where, which is my area of expertise, where we're going after money damages, compensation for the injuries, if you may. I am held to a burden of preponderance of the evidence simply because we are limited to that sort of damage. Whereas in a criminal aspect, where Ross Watson does his work, we are looking at more of a beyond a reasonable doubt. And the reason there is because we're looking at taking away a person's most prized possession, and that is their body, and actually incarcerating them.
Okay.
And in some situations, actually taking their life.
Right. I knew there was a definite difference, and I couldn't remember where they applied to, so that clarified it.
Yeah, yeah. So, like, for instance, here's another case that talks about despite the defendant's claim of self-defense, conviction for assault was supported by legally sufficient evidence that defendant hit the victim before victim ever attempted to pull the gun from the back seat of the car. In other words, the defendant provoked this situation, and the jury felt like he provoked it, and under the penal code that we just talked about, he does not have a right to have a self-defense verdict in his favor.
Wow.
So
This stuff
then,
gets so twisted, man. That's what you just gotta either have a good attorney in your back pocket.
well,
or
here's
know
some more
this law.
twist to it. And although the defendant provoked the fight, if it ceased and afterward the deceased renewed the quarrel, defendant would not be deprived of the right of self-defense. In other words, even though he may have provoked it, if there was a time period in there where things kind of de-escalated, but then the deceased came back and said, "Oh, I'm going to get you now,"
Right.
then he
Has the
could
right for
pull his
self-defense.
knife out or his gun out and take care of business and still have that right of self-defense. But you see, when you talk about things get twisted, what we got to understand is the jury gets to hear these facts and make the determination of whether or not these particular laws affect the case.
Couldn't it take into effect that the first argument set off the other guy, even though the first guy backed off, the other guy was steaming, but he wouldn't have been steaming had the other guy not done anything in the first place. So even though the first guy backs off, the other guy's steaming and he comes back, isn't it really saying that because of the actions in the beginning, this guy would never have had this attitude if the actions at first never happened, so then it can fall back on him where he doesn't have the right of defense?
Well, attitude and actions, of course, are separated. And even though I may have a bad attitude, that doesn't give me the right to action. So if there is a bad attitude and there is a de-escalation of the initial conduct, the provocation, if you may, then everything needs to back away. Now, here's another twist into it. If one intends to provoke a difficulty, and although the means used are not reasonably calculated to provoke, yet if they do in fact provoke, he is responsible for what he actually intended to do. So that's really, to me, that's really twisted. But hey, that's what the case law says. The Texas Court of Criminal Appeals has used that in a 1900 case, and it is the law today.
Can you explain that in a simple term?
Well, it's kind of hard to, but it has to do with provocation. In other words, if I were to provoke a situation, and I meant to provoke it, but I said something like, your mother wears army boots. That's not something that would normally provoke someone else to pull their gun or knife out. But gosh,
I don't know.
in
Sometimes
some
there is,
situations,
yeah.
it must.
I guess. All right.
So he is responsible for what he actually intended to do, because maybe he knew that the person he was talking to was of such a culture that,
That's right, yeah.
that would really upset him to the point of provoking them.
And that's rhetoric.
Yeah. Mm-hmm. Exactly. So then if we look at an act, that's going to be more provoking than words. And of course, if the act itself is provocation, like pulling a knife or pulling a gun, and you couple it with words, like I'm going to shoot you or I'm going to stab you, then that's pretty solid provocation. But it's still a question of fact. It's what really happened. For instance, how often would you hear a defendant on the witness saying, yeah, I intended to provoke this? So you got to get into, well, what kind of facts and what kind of evidence would clearly show that he had intended to provoke this. So there you get into something like arming yourself. And the law is pretty clear that just arming yourself and going to talk to someone about a situation, a difficulty, if you may, in other words, asking for a explanation about why it is you scared my wife, is not provocation in and of itself.
I'll tell you, I want to say a statement. You tell me if it's, in your opinion, correct. A person, let's say with a license to carry, if you think it's cut and dry, your decision-making process, it would be a fair statement to say, correct me if I'm wrong, that when you go to the courtroom, if you have to go to court, all the things that you thought about or knew about before you got into that situation is going to be a fraction of percent of what the attorneys and the court and the laws are going to hit you with, like preponderance of the evidence, rhetoric, and all these different terms we're talking about, all these different things you have to analyze, that you're going to be in store for a big surprise, cost a lot of money, potentially even take some of your time and alter your life. And that's why it is so important to know your mindset, your mechanics, your laws, and whatever else that can supplement or aid and assist you in keeping yourself alive and out of jail.
Absolutely. You get another attaboy today.
Well, gee, thanks.
So the concept is, though, that everything is supposed to be looked at through the eyes and the mind of the defendant. In other words, what did he perceive? So if you are in a situation where you're trained and you're cool-headed, you can be observant, you can analyze your observations in such a fashion that you will not make mistakes. And if you have a license to carry, that means you've taken certain classes and done certain research, studied certain things, and your words then in the courtroom would be perceived by the jury to have more effect than if you were just somebody that had 7 prior felonies for assault.
I train, I read, I listen, I study. And because of that, I've come to the point where in my mind I have lines in the sand. And there's different situations. There's invasion of the home, assault on the street, protection of a third person, protection of a third person's property. I have all these red lines in the sand as it must get to this point before I will do anything because it's not worth it. So I'm thinking, people out there, that's why it's so important to know yourself, know your mechanics of your weapon and surrounding areas, know laws, know all these different things, and realize not just to look at the situation, but 10, 20 steps beyond the situation as to what can happen, and draw your red line, say, it doesn't matter what the law says, I don't care what people are going to think. I felt it was necessary at that point in time in my life to do what I had to do. Otherwise, you're going to be in for shock, attorney fees, and possible jail time.
Well, and also, like the defendant that's sitting over in the jail, I think in Coryell County now, who shot a couple of policemen who were knocking his door down and running in the dead of night, like at 2 or 3 a.m. – He said he'd rather be, 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 he sa convicted by 12 rather than carried by 6. So, so
Yeah.
you know, sometimes we make mistake and the aftermath is bad, but if we don't make those mistakes in the law, sometimes the beforemath might be bad.
Right.
So those are all things, though, that if you are trained and if you study and you consider all the facts in front of you, you won't make those mistakes and you won't be carried by 6 and you won't be convicted by 12.
Ladies and gentlemen, I have Rick on here. I have Ross on here. If you go to aaronsgunshop.com and go to the YouTube channel, I've got all these videos. You need to go look at them. It's free advice, and you need to remember these guys and put their numbers in your phones, and God forbid if anything happens, you need to call them. They're experts in their fields. They know what they're doing. They can help you out. I'm sure you can get a consultation if necessary. I'm not sure what you provide on a consultation. First one free. Do you guys
Well, generally, I tell them whether or not I think their case is valuable, economically feasible, worthwhile, and if it's not, I generally tell them why not.
Okay, so you're going to know right up front, pretty much, from an experienced attorney who's been around the block many times, knows what he's doing. He can assist you. But I'm telling you, you're foolish, especially if you got a license to carry, and don't go to my YouTube channel and look at all these videos. We've gone over tons of stuff, and we've gone over things 2 or 3 times with different angles at them to just clarify even more some of those penal codes and other laws. We're running out of time, Rick. Do you want to encapsulate this somehow? Everything you talked about with rhetoric when it comes to personal, political, whatever it
We
was.
talked about it. Let me throw in another little ending thing here about how rhetoric has changed. Some of the case laws I read that talked about how words alone, if clearly designated to do so, may provoke. Like calling a person son of a harlot would be sufficient provocation to preclude self-defense if induced cause of difficulty. In other words, if I go up and I call someone son of a harlot back in 1898,
Yeah, that's bad.
we might use different words today, but it would be the same thing. And if I did that and that would provoke someone then to attack me, and I intended them to attack me so then I could kill them, then I can't use self-defense.
Self-defense, right?
Yeah.
Okay.
So provocation, rhetoric, it's kind of the same thing. That's what we're looking at in the penal code. One way if you provoke an attack so that you can shoot someone, that ain't good. If you attack someone who's just using rhetoric, then that ain't good. So
Let me add this to that. I saw this from the comic page, Rubes. So one squared comic. And it goes, you got 2 vultures sitting on the skull of a steer there. It says, the name calling, the backbiting, the accusations. Frankly, I just can't stomach politics anymore. And considering our diet, that's saying a lot. Okay. That's a good way to wrap
the
it up.
vultures, they're always on the hunt.
That's it. Rick, tell everybody how they get a hold of you.
Oh, they can look at respectforyou.com and look at some of the stuff that we do, and they can look at some of the accolades that we've accomplished as far as our education, experience, study, interactions, things of that nature. They can call us. They can come by 312 South Houston. There's all kinds of ways. We've been here for 38 years. We know what we're doing. Give us a shout.
Fantastic. Rick, thanks a lot. I can't tell you how much we appreciate your support. Joel, let's take a break, and when we come back, we're going to do something. Probably going to be topics of interest, and then we'll have the delicious Janae Goodman before the top of the hour. See you on the other side. Very good, sir.
All right.